Good afternoon, everyone. I'm Alex Kennedy, solicitor in the employment and disputes teams here at Gannon's. So generally, I'm asked to step in when something has gone wrong. So with any luck, after today's presentation, you won't need to speak with me very much at all. And instead, you can concentrate on instructing Catherine and the rest of my corporate and commercial colleagues on managing, growing, and selling your businesses. So I'm going to speak about how these upcoming changes, which are very seismic, there's really quite significant changes, will impact, in particular, the hiring and firing of staff. The idea being that any company that has staff will need to tackle these issues. I do expect that I'll have some time for questions at the end. What I'd suggest is if the chat function is available, which I think it should be, if people just drop questions as and when it occurs to them, and then I will try and mop up everything at the end of the seminar. So, first things first, we're here to talk about the Employment Rights Bill, which will receive royal assent in the next few days, or certainly by the end of the month, and become the Employment Rights Act. This will make the biggest changes to employment law in a generation. So while I'm focusing on hiring and firing, that is only one aspect of the changes that this bill will introduce. Just to touch again, I suppose, echoing slightly something that Catherine said in her introduction, we understand that these changes will be of particular concern, or maybe of particular concern to smaller firms, which have, traditionally lighter HR frameworks, fewer dedicated HR personnel. Our message today is that with adequate preparation, you will be able to embed a culture of fairness within your workplaces, which mean that you are unlikely to be troubled by the Employment Tribunal. And actually, that's true in terms of that protection. It will protect you under the new regime, but it will also protect you now. So that sort of goes hand in hand with the other part of our message, which is while some of these changes are coming on down the track, you should start changing the way you are thinking about these things right away. So while most of the focus is going to be on hiring and firing, I just wanted to put in, I suppose, in perspective some of the scale of these changes by talking about the changes that are coming in the bill and when they're coming in. So the Employment Rights Bill was a real keystone part of the Labour government's manifesto and was introduced very shortly after they came to government last year. There are at least 28 separate reforms, depending exactly how you count them, introducing swathing reforms to huge aspects of employment law. So everything from dismissal rights to the way trade unions operate to sick pay and lots of things in between. The government has said that this is all about making work fairer and more predictable. And by that, they mean fairer and more predictable for employees. So I think it is inevitable that this will have an impact on business, but that impact can be managed, and that's partly what we're here to discuss today. The implementation is going to be staggered over at least a couple of years, so some of these measures will not come into effect until late 2027. And in fact, this slide sort of is a timeline showing how we expect these reforms will roll out. So in very soon, this autumn, soon after the bill receives royal assent and becomes the Act, we'll see some of the initial changes. These are mostly rules about how trade unions operate, rules about the right to strike, how polling operates, that sort of stuff. Frankly, not of particular interest to anyone other than sort of trade unions and practitioners. By the middle of next year, so by April 2026, we'll start to get some of the more substantive reforms. So there will be a day one right to certain rights which normally you would expect to come in later on in an employment relationship. So rights to unpaid parental leave, for instance, and paternity leave. Statutory sick pay will start to work in a different way. So it will no longer be payable after the fourth day of sickness. It will be payable on the first day, still at that relatively low sort of nominal amount. And then there will be certain protections for whistleblowing, which will be enhanced. Really, what that's seeking to do is dovetailing in with extra protections, which will come in later in 2026, about the employer's obligation to protect against things like sexual harassment. So the method of raising complaints about sexual harassment will change as part of the whistleblowing rules, and then that sort of additional duty that falls on employers to prevent sexual harassment will come into effect later in the year, in about October, is the expectation. It may be that we'll run further seminars on that topic. That is itself a very big topic, and something that employers should be on the lookout for when it comes into effect next year. And then right towards the end of the implementation period in 2027, probably about this time in 2027, in October 2027, there will be a day one right to protections from unfair dismissal, which will effectively usher in all of the changes that we're talking about today in terms of hiring and firing. So with that in mind, you might sensibly ask, Alex, you're signaling all of these changes that are going to happen first. All of these changes that are going to happen earlier than the changes to hiring and firing. Why are we talking about this today? Well, the reason why is this change. It's quite a simple change mechanically. All they're doing is stripping out the requirement that an employee needs to have 2 years continuous employment before they can bring a claim for unfair dismissal. But that tweak actually signals a really fundamental change in how we think about employment. So gone is that 2-year window before employers needed to worry about whether staff can bring unfair dismissal claims. And as a result of that, the expectation is going to be that fairness and fair processes need to be embedded right from the very start of the employment. And that's something that it's not just directors and HR professionals will need to be thinking about. It's something that anyone with management responsibilities will need to be thinking about. So any line manager, anyone who supervises staff, will need to be on board with these practices, because and I'll go on about this later on, but they are the ones who are ultimately going to be running probation reviews, running performance management, giving feedback, documenting performance. If they don't do these things, then businesses as a whole will be exposed. It also means that employers need to look again at some of how their contracts and existing policies work. So it's quite possible that your default template employment contracts will include something like a probation clause. But that is going to become suddenly a lot more important, as we will talk about at length in this seminar. So I think we will be asking people to, or people ought to go back to their documentation and review it and see if it's fit for purpose. So frankly, we've got 2 years to think about these changes, but we will need it. We will need that time. And there is a benefit to embedding these practices now, because, of course, if you follow a fair process so that it would stand up to an unfair dismissal claim in 2 years' time, when these claims would be possible, that claim would also presumably stand up to a claim for something like discrimination, which doesn't have that 2-year limit. So if you are following these fair processes now, you are protecting yourself from all sorts of claims, even that are possible to bring by employees now. So I've already talked about it quite a lot. I've used, throwing the term unfair dismissal around, and I will continue to talk about it throughout the rest of this talk. So I thought it would be useful to actually explain in some detail what it is. And it can be a bit of a strange concept if you're used to dealing with commercial contracts. You can terminate a contract typically on notice, following whatever the termination provision in the relevant contract says. And frankly, it doesn't matter if you do it nicely, or if you do it for a particular reason, oftentimes. Not the case with an employment contract. So employment contracts will have notice provisions. You might have to give 3 months notice to terminate someone, for instance, unless they've broken the contract and sort of committed gross misconduct. But unfair dismissal is a separate idea. It's a concept that comes from statute, and it means that not only do you need to dismiss someone in accordance with the contract, you also need to dismiss them fairly. And dismissing someone fairly means dismissing them for one of a number of potentially fair reasons, which are the 5 that are listed that I'll talk about in a second. And you also need to follow a fair process. So you need both of those things. You need a potentially fair reason, and you need to demonstrate that you have followed a fair process in order to be confident that you have fairly dismissed someone and that someone can't bring a claim for unfair dismissal in an employment tribunal. The potentially fair reasons for dismissal, I'll run through these quite quickly. So capability, so this is the ability to do the job. So perhaps people who are performing poorly in a job would be dismissed as a result of capability. Conduct, so this is sort of the way in which people conduct themselves in the workplace. So that could be the sort of very serious hand in the till or fraud, but it might also be persistent lateness, rudeness, the manner in which they conduct themselves in the office. Redundancy is the sort of stereotypical, it's not you, it's us. There is a reduced need for this particular role at this particular time, perhaps a slowdown in the market or a change in the way the business is operating. But yeah, generally speaking, not about the individual performance of the employee. Statutory restrictions, this is referring to legal bars to employment. So perhaps the employee in question has lost their visa. It's a good example. And then the final catch-all category is some other substantial reason. So this might be a fundamental breakdown in trust, but for some reason other than capability or conduct, or a reorganization that means there's a reduced need for the role, but which doesn't fit the strict technical definition of redundancy. It exists as a catch-all category. By and large, as practitioners, we try not to use it because you face a bit of an uphill battle in a tribunal convincing someone that some other substantial reason applies, and if you can fit in one of the other categories, you are generally better. So in order to fairly dismiss someone, you need to have one of these potential reasons, and you need to follow a fair process. So if you are dismissing someone for poor performance, you will need to show that you have warned them that their performance is poor, that they are some expectations that they're failing to meet. You need to give them an opportunity to meet performance targets, perhaps put them on a performance improvement plan. And you need to sort of manage that quite carefully. Conduct, similarly, if you're instigating a disciplinary, you need to follow a fair disciplinary procedure, make sure it's carefully documented, all the rest of it. We'll talk a little bit more about fair processes throughout the rest of this talk, but the crucial thing to take away is you need both of those things in order to dismiss someone fairly. And at the minute, you don't need to worry about this generally until an employee has 2 years continuous employment. That's the big thing that's going to change. So yeah, 2 years service required, except for discrimination and whistleblowing complaints. That's changing, and we say you should start thinking about that change in mindset right now. So the way the Employment Rights Bill is going to work, it gives this day one protection against unfair dismissal. Mechanically, as I've already alluded to, the way that works is it's simply stripping out the part of the existing legislation that has that 2-year window. So it will say, this is what, the statute will now read, this is what unfair dismissal is, and all employees have that right to bring a claim for these things. To cushion that a little bit, it seems that there is going to be this new concept of a statutory probationary period or an initial period. The government is consulting currently on how long this probationary period would be, exactly how it would operate. Importantly, it's not going to be a replacement for the existing 2-year window. It is so it's not going to say employees with less than 9 months continuous employment can't bring a claim for unfair dismissal. Rather, it's going to say that during that initial period, it will be possible for employers to terminate employment on the basis of a light touch dismissal. But we don't quite know what light touch dismissal means. And it would still need to be a fair dismissal. So I think probably prudent employers who want to ensure fair processes and want to avoid employment tribunal claims will probably be adopting, uh, a relatively robust uh, approach to performance review management, managing probationary periods, which we'll talk about in a second, even though they are within this initial period of employment. I think almost a way of thinking about it is, well, it does mean that you'll be able to dismiss someone for, something like cultural fit, which might be more difficult to do later on down the line. Okay. Yes. So this is just summarizing the position that I've already said. So currently, we don't tend to worry about unfair dismissal if someone has less than 2 years continuous employment, assuming there's no discrimination involved. Just as an aside, because I'm conscious I'm talking a lot about discrimination without defining it. By discrimination, we mean a dismissal that is informed by one of a number of protected characteristics. So someone who is dismissed because they are a particular sex or gender or sexual orientation, have particular political beliefs or religious beliefs, or if they're disabled. So those are the sort of things that would give rise to discrimination claims, and you do not need to have 2 years continuous employment to bring those claims, even under the current rules. In the future, unfair dismissal is day one right for everyone, with this lighter touch regime that I've alluded to. So the message that I really want to drill home is preventing an unfair dismissal claim, or indeed preventing unfair dismissal, making sure that any dismissals are fair, starts from day one of the employment. It begins with the induction. So whenever you are bringing new staff on board, it's important that you make sure it's very clear to them what is expected of them, not just in terms of their day-to-day tasks for their particular role, but also how they should conduct themselves and the values of the company. You know, is this a relaxed workplace? Is it not a relaxed workplace? Are there any particular sort of political sensitivities, or are there staff with particular particular protected characteristics that need to be honored? All of those sort of things. Again, sort of defining these things early with a quiet word and setting expectations may well prevent disputes and problems arising in the future. Also important that sort of having some of these discussions at an early stage might well prevent claims from the employee themselves. So, for instance, it's important to know if someone has a hidden disability and might need particular reasonable adjustments to the workplace or the way they conduct their work. And having a policy in place that you, for instance, ask new joiners to fill out a form to say to indicate confidentially if they've got hidden disabilities, that can be very useful. So, as I say, it starts from day one with induction, but it should be a continuing act. So supervision and feedback should be structured throughout probationary periods, which we'll talk about, and throughout the life of the employment. There should be opportunities for employees to sort of check in with managers. Managers should be actively checking in with their employees. Documentation is vital. So this doesn't need to be chapter and verse, but a note of X met with Y and discussed X will be very helpful in the future if you're demonstrating that, look, these discussions were, being thought about. We were actively having them, and throughout the life of the employment. That's the sort of evidence that employment tribunals love to see. Deal with issues as soon as they appear. So if you become aware of an issue, it should be addressed informally in the first instance, and sometimes a quiet word on, as soon as an issue arises, will prevent a much more serious grievance from an employee or dispute on down the line. The sort of oh yes, and finally, the very important point is making sure that these are policies which are embedded and are applied consistently across the workforce. And I think embedding policies will enable you to make sure you are treating people consistently and fairly. Short, this is not just a compliance exercise, it's a management habit and something that needs to be drilled into people as they walk through the door. So we know that the government's intention is that employees, or rather, sorry, employing firms will use probationary periods as a way to fairly dismiss people during that, at least during that lighter touch period that I've alluded to. So probationary periods aren't new. As I say, most likely your template employment contracts already include probationary periods, which perhaps say that you can dismiss on shorter notice for perhaps the first 3 months of employment. But probationary periods are going to become a lot more important because theoretically these people have protections against unfair dismissal from day one. And the probationary period is your opportunity to make sure that the employee fits with the company, is able to perform the role that you're asking them to perform, fits with the cultures and values of the company, all the rest of it. So probationary periods need to be used actively. This is not any longer a clause to be written into a contract and then forgotten about when the contract's signed and put in a drawer. The probationary period needs to be active. There needs to be consultation between the employee and their line manager. The employee needs to know whether they have successfully completed their probation. That needs to be very clearly communicated to them. And there should be documentation throughout the process. This is all to say that line managers are going to be crucial here. They are the people on the ground managing the probation policy, managing these performance reviews. They are the ones who need to set the expectations, which means in turn you need to set your expectations with them. So they are going to need to be scheduling structured review meetings. They need to know when it's appropriate to document things, how it's appropriate to document things, etc. And they need to have the confidence to be able to address issues. So either proactively themselves, they need to know when it's appropriate for them to step in and handle things with those sort of informal chats that I've talked about. And they need to know when it's appropriate to escalate things as well. And look, it's all very easy for me to say that as a lawyer. I understand these are difficult interpersonal dynamics, and in small companies, small teams, this can be really quite difficult. But these are things that employers are going to need to think about going forward. Just taking a look very quickly at some contrasting examples. So take a very stereotypical example of bad practice, which happens all the time. A manager hires someone, never holds a performance review meeting, but at 6 months decides the employee simply isn't working out, looks to dismiss. There's no paper trail. The dismissal comes as a complete shock to the employee. They're very upset and disgruntled. But under the current regime, unless that employee has a protected characteristic that they can complain about, there's probably not very much recourse to that employee. And switching my hat, and I advise employees as well sometimes, and they will say, well, this feels very unfair. And I will say, yes, it is definitionally unfair. It's just you don't have a protection against unfair dismissal. So that's why it feels like that. But that's very bad practice, and actually does leave, even under the current regime, leaves employers exposed to claims for discrimination. Because if that employee can say, well, I think the reason I've been treated differently or badly is because of a protected characteristic, then they can bring a claim in the employment tribunal. And those are the sort of claims that can be very expensive to settle, very difficult for employers to manage. So the second example, good practice. The manager holds reviews meetings regularly. So perhaps, in a 6-month probationary period, they meet in months 2 and months 4. They set objectives. Clearly, the employee understands what's expected of them, have key measurable metrics that they can meet. Everything's documented. And if, you are, by that way, you are identifying issues early, giving people opportunities to improve, and have measurable metrics so that if problems persist, the employer can show that if they ultimately dismiss someone, they acted fairly. So that is best practice now, would prevent something like a claim for discrimination, but it will also stand up to scrutiny once unfair dismissal becomes a day one right. So you can see this is all about practice management and habits, which should begin to be being formed now. Let's talk about some specific examples, put some hypothetical names to some of these cases. So here we have Alice, who's a new salesperson. She's about 5 months into her employment. She's struggling to meet sales targets, has received some informal feedback, but hasn't had any sort of formal warning or formal process. Currently, a company would probably feel pretty confident that they could dismiss Alice without much concern. Again, assuming they're not dismissing her because she's, a woman or because she's got some other protected characteristic. However, after the Employment Rights Bill comes into force, this is exactly the sort of situation which could give rise to an unfair dismissal claim. So, how should that be dealt with? Well, they need to follow this fair process. They would need to set clearly the expectations, show how Alice is failing to meet the expectations, giving her an opportunity to improve, explaining that the consequences if she doesn't improve is that she might be terminated. So in other words, they need to set the groundwork for a fair dismissal on the for capability, so her ability to do the job. On the next slide, we've got a similar example, but here the issue isn't capability, it's conduct. It's the way that Bob has conducted himself in the workplace. So again, he's a new hire, very new in the job, but within the first few weeks, it's clear he's not fitting in. He's being generally rude to people, not fitting in with the team, perhaps some minor issues in terms of disciplinary issues, but perhaps not something that would be sufficient to dismiss someone immediately for gross misconduct, rudeness, lateness, that sort of thing. Again, under the old approach, a company would feel pretty comfortable that until Bob reaches 2 years continuous employment, they could dismiss him. And actually, that probably means that they might put up with some pretty bad behavior right up to the point where he's about to get 2 years continuous employment, and then they'll make a decision as to whether to keep him or to fire him at that point. That's not going to cut the mustard anymore. So again, you would need to go through a similar sort of fair process. Here it would be something like a disciplinary process rather than a performance management process, which was the case with Alice before. So I've talked quite a lot about performance management during the probationary period. That same process of pretty regular check-ins, regular setting of objectives, setting of targets should continue throughout the employment relationship. So perhaps have a policy of meeting with people on a quarterly basis, or and actually talking to them about what the expectations of their role are, whether they're failing it, whether they need any support to help them reach their the expectations of their employment. And I think a good way of thinking about this is that thinking about the documentation. So actually, sometimes we see employers who have these huge, long, detailed forms. They run for 12 pages. They're entirely unwieldy. And they ask the employees to fill out these things. And, the employee inevitably fills them out at the last minute without a lot of self-reflection. And say, oh, yes, I think I'm meeting expectations. And then it's all put in a drawer. That's no use to anyone. I think a much better approach is to have very straightforward documentation, which is actually used consistently and is used actively, and that's something we can help with, and we can help with employees sort of design something that's quite bespoke, or employers design something that's quite bespoke that fits their particular employees. Handling underperformance and disciplinary issues, these sort of things should be dealt with early, first by an informal process and then by a more formal process. Nothing should ever come as a surprise to an employee. And if something is coming as a surprise to an employee, that's probably a good indication that you are conducting a process that is unfair. And remember, that's one of the limbs or one of the ingredients that might lead to an unfair dismissal. So yeah, running through a sort of an example of a fair process. So you perhaps have an employee warned in a mid-probation review that their sales are 30% below target. They're given a performance improvement plan. By month 7 under that performance improvement plan, targets are still unmet, but everything's been documented. We know that there was an expectation that was set, it hasn't been met, and therefore that employer is going to be able to dismiss an employee safe in the knowledge that they will not likely face an unfair dismissal claim. Unfair examples, exactly the opposite happens. Someone's taken by surprise. They are dismissed without a lot of warning, and they feel aggrieved and much more likely to bring a claim. So, yeah, that's the situation to be avoided. And then this third scenario, I just wanted to throw in as well. Again, this is an employee who has been there a little longer, at least 1 year's continuous service, but this is someone who would still, under the existing regime, would not have a protection against unfair dismissal. And this is sort of what I was getting at before, where employers, I think, have a habit of putting off the decision of whether they're going to keep someone on until perhaps a year and a half in, whenever they know, oh, well, if this employee stays for very much longer, they're going to pass a tipping point and then become that much harder to dismiss. And I think that's a dangerous mindset now, frankly, because if you are of that mindset and then you do dismiss someone after they've worked for you for maybe a year and a half, they might be justifiably very aggrieved, and they will be very motivated to think of any angle they possibly can to bring a claim. And that's why you have people sort of hooking claims on protected characteristics, claiming that it's discrimination, when perhaps that might actually be something that's very far from the minds of everyone. Very few employees, I think, frankly, these days are racist or are sexist. Obviously, there are some. But I think where people tend to get in trouble, from my experience, is where they fail to follow a fair process, and it sort of almost forces the employee into thinking creatively as to whether they've got a claim for discrimination in order to be able to bring a claim. Once the Employment Rights Bill fully comes into force, I think we'll actually see a bit less of that. That's just my pet theory, because employees will have a much more obvious recourse, which is just, well, either there was a fair process or there wasn't. And my message to all of you is make sure there is a fair process by following this advice. Great. A slightly cheeky slide here. What if we got it wrong? What if we fail to follow a fair process, or we are in a position where we're facing an employment tribunal claim from an employee? The slightly good news is that almost all claims in the employment tribunal settle, and many of those settle long before they ever reach the employment tribunal or even reach ACAS. Most employment disputes settle in the form of a settlement agreement. I expect many of you will be extremely familiar with settlement agreements. This is an agreement whereby the employee agrees to waive their rights to bring particular claims in exchange for enhanced consideration. It can be very attractive for employees because they get some of this payment tax-free, currently up to £30,000 tax-free, if it's paid as settlement for loss of employment. So employees are very incentivized to take it. The carrot being the money and a tax-free sum, and the stick being, well, the alternative is facing employment tribunal proceedings, which frankly it will be daunting for an employee as well as an employer. So there's strong incentives on everyone to settle these cases. And if you are in a position where you need to settle an employment claim, we can help. We can help draft settlement agreements and negotiate those with employees. Very well versed in those. Some practical tips, touching on some of the things that I've been speaking about throughout. So what can we do now? We can review contracts, make sure things like notice periods, probationary clauses in particular, I think will be extremely important going forwards. Train your line managers, and I think this should be more than sending an email and saying, oh, you need to be become good at this. I think this needs to be some active training. I'm sure that HR providers are able to put training in place. We would be very happy to come in and speak with line managers. For some of our valued clients, we'd be very happy to put in place some training. And I've put up on the slide here role play scenarios. I think actually playing through these scenarios, because people will be reticent to engage with issues, even if they think, oh, I really should intervene here, or this is someone who's struggling a bit and needs some support or whatever. I think people need to be used to identifying and sort of intervening in these sort of circumstances and knowing when to step in and how to step in. I think this is particularly important for employers who have a lot of staff who work from home, for instance, which will be, I expect quite a lot of you might be in that position where a lot of your staff work remotely, and it can be difficult to know actually if someone is struggling. And of course, if someone's struggling, ultimately, the responsibility for making sure they are supported rests with the employer. So I think training line managers is an important tool in your arsenal. Create templates. Again, this is what I was getting at before. I think a 1-page or 2-page document that is actually practical and uses and speaks to the requirements of your particular workplace is much more useful than a much longer document that is entirely unwieldy and inappropriate. Introduce simple templates and use them. And keep consistent documentation. So again, I think consistent documentation will feed into consistent processes, which will ultimately protect you and your business. The headline point is the aim of this legislation is to try and bake in fairness from day one of employment, to break that link that has, I think, developed where employers only think about fairness when employees are coming up on 2 years continuous employment. And to be to to advocate for that movement for a moment, I think if you do follow these things, I think you will have better performing businesses. You should see improved performance. You should see improved productivity in the form of improved performance. You should see lower staff turnover, fewer complaints, and ultimately you should see more money. That we're all, these. I think I'm speaking entirely to for-profit businesses here. Ultimately, it's all about the best business practices, making sure you are building strong, profitable businesses. So yeah, this is not just a legal necessity. It's good business practice. More money in your coffers is the headline. So final thoughts for me. Start adapting now. Don't wait until this comes into force in 2027. Manage probation actively, and documentation is the best defense. Make sure you are able to evidence all of this great compliance through simple evidence that is actually used. Does anyone have any questions? How do the rules vary for directors? That's an excellent question. So directors, first of all, not all directors are employees at all. Directors, what they will all do is owe fiduciary duties to their company. So I suppose the fact that they owe fiduciary duties to act in the best interest of their company for the benefit of shareholders will sort of puts a gloss on their relationship, the relationship between directors and their companies. But for employed directors, I think all of this would apply. So someone hypothetically who's taken on as a director and is then dismissed pretty soon after would still have a protection against unfair dismissal and would be able to bring an unfair dismissal claim even if they haven't worked for the company for very long. I expect that might become an aspect in a lot of director and shareholder disputes, which we do lots of here as well. What happens to existing employment contracts signed before the implementation day? Do they automatically acquire day one rights? The answer to that question is yes, I think they will. And 9-month probation, irrespective of what is written in the contract. Yeah, I think so. The 9-month probation, I don't think we actually know yet. So the government is currently consulting on it, and the intention seems to be that this period is going to be 9 months, but it might actually be that by the time this legislation is implemented, it's a different period. I think the purpose of it being a 9-month period is their assumption is that most companies will have a contractual probationary period of 3 months or 6 months, with perhaps the capability of that being extended if someone hasn't successfully passed their probation. So I think the idea is that you have maybe a 3-month, which might be extended twice, or a 6-month probation, which might be extended for further 3 months, and that's how you get to 9 months. I think someone who doesn't have a probationary period at all in their contract technically wouldn't be on probation, but I think they would still fall within this light touch sort of dismissal regime. But yes, there's still a bit of a caveat about how that's going to work in practice. If they breach their director's duties, does that constitute cause for terminating their employment contract? Not always. Sometimes. Depends what the breach is. And also, obviously, depends on their employees. Will there be any point of probation clauses and contracts in the future? Yes, there definitely will be. The statutory, I don't think the statutory probationary period is going to be a replacement for probation. So rather, I think it is going to operate as a period of time in which it's possible to dismiss someone on this slightly light touch basis. But I still think it's useful to have a contractual probation clause, which will satisfy the requirements that probation clauses satisfy at the minute. So you might have a period of time when you might dismiss someone on much shorter notice. So you might dismiss someone on a week's notice when their contractual period of notice is a month or 3 months by the end of probation. I think it's also useful in setting the intentions and expectations of the employee, and it's useful for baking in this performance management, which all feeds into everything I've been discussing today. But yes, I think probation clauses are going to be very important in employment contracts, and actually, I don't think the statutory probation period is going to necessarily imply probationary periods into contracts of employment. I think it's just going to sort of create this window when it's possible to dismiss someone in this light touch regime.
Right. Okay, Alex, I think you've been extremely extensive.
Okay, no problem.
And we'll wrap up here. Really, really helpful. Listen, as an employer, you can often feel out in the jungle exposed, not knowing what to do. And one point Alex made that as an employer, I'd like to pick up on is putting off the decision, because that's now soon going to be the worst thing you can do. But it's a very hard decision to make. But my team, Alex, another Alex, Jason, me, we're always here. Just pick the phone up and say what you think. Is this crazy? Because everybody needs some support on this really fundamentally difficult question. Because so much effort goes into recruitment, I know that. And it is so disappointing if it's not working out. It's really tempting to delay. But as you've heard from Alex, that's going to cause you more problems. So all I say is, if you remember anything from today, pick the phone up and ask us questions. And you don't have to speak to me. You can speak to my more knowledgeable team. Okay, so on that, I think we'll say thank you very much indeed. We're going to be having some more seminars going forward, a question and answer type format where you put your questions in and we'll answer them, probably split between share and constitutional questions on how you organise your company and employment, aiming to do those around about once a month. So I suppose you'll be hearing from us again. Thank you very much.
Lovely. Thanks so much, everyone.